Investment advisory services offered through Global Financial Private Capital, LLC, an SEC-registered investment advisor. Global Financial Private Capital, LLC, and SWAN Capital are independent entities.
What your money would say. Andrew McNair. Money Talks. Are you listening? Money Talks. Are you listening? Money Talks. Are you listening? What your money would say with Andrew McNair.
We're live here on What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And on What Your Money Would Say, we pride ourselves on taking ugly financial ducklings and turn them into financial swans. But what does it mean to be a financial swan? I named my firm SWAN Capital, which is in the downtown heart of Pensacola. And we specialize on helping retirees just like you who've checked the box and prepared for retirement, who put 3 kids through college, who saved money in their 401k plan, and even gave to their local church and their local charity. Make sure that they sleep well at night financially.
And I started the law offices of Scott Malleck to help my clients do timely planning for untimely events like death and disability. That's why I focus my practice on estate planning, estate administration, and elder law.
And so one of the topics that keeps our families from sleeping well at night is probate. You know, they've heard about it maybe through, Joe at the water cooler. They've heard some horror stories here and there, but they really don't know how the process works. They don't know how to prepare for it. So what we're going to do is we're going to peel back the curtain and make sure that you understand what probate is and how to prepare for it. And remember, this show is live. So if you have any questions for us here on What Your Money Would Say, give us a call at 478-3116. That's 478-3116. So, Scott, let's jump right into it. Let's talk about fire drills. Why do we do fire drills?
Well, last time I checked, it was to prepare for fires.
Right. It's common sense. But, it's one of those things we don't really like to do. We have to, stop either our work schedule, or when we were at school, we had to stop our schoolwork. And we had to,
in school, I liked fire drills.
That's true. And, we have to interrupt our life because we want to prepare for the real thing, right?
Yeah, because, the last thing you want to do is, when the real thing happens, be unprepared.
Exactly. And so with that, keeping that in mind, I haven't checked in 2015, but what's the likelihood of death right now by a percentage basis?
I think the last time I checked, it was 100%.
Oh, that's right. They still haven't got that thing figured out. But, since death is about 100%, and it's a topic we don't like to talk about it, it's not an if thing, it's a when thing. So we have to prepare, because if we're not careful, we will leave our legacy in shambles and disarray when we check out of this earth.
And it can also make it extremely difficult for our loved ones, when they're dealing with the grieving process, because that's the last thing anybody wants to do is have their loved ones have to deal with
financial turmoil.
Yeah, financial, legal turmoil of, these probate matters, when they're dealing with the loss of a loved one.
That's so true. So, they say, funerals are not for the dead, they're for the living. Well, estate planning is the same way. It's not for the person that's passed. It's for the people they leave behind. And we want to make sure that when you check out that you're going to leave your affairs, your legacy in order and have a seamless transition for your family. And so let's jump right in and talk about what is probate, Scott.
Well, in Florida, there are 3 different levels of probate. There are 3 different levels of administration in probate. The probate itself is actually a court-supervised distribution of a person that passed away's assets.
So it is actually a court of law.
Exactly. So, the probate court is an actual division within, say, here at Escambia County.
With judges.
Yes. So there's a judge that's predetermined to oversee the probate process for the probate court for that particular week or month or whatever. The court has their own calendar,
Exactly. So, and there's a lot of misconceptions there that, that's, for people that have lots of assets. Could you break down those 3 different?
Yeah, exactly. There are 3 different types of administration in Florida. You have no administration, which is when you have only enough assets or money to pay for your last illness or your 60 days of your last illness or your funeral expenses. Then you have summary administration, which is when you have assets that are probatable that are less, but those assets values are less than $75,000 in total. And then you have formal administration, which is anybody that has probate assets that are valued over $75,000 in total.
$75,000 is not a lot of money, though.
It really isn't, and
especially with a home. I mean, If you have your home paid off, you're there right then.
Exactly, and I have a lot of families that come in and they think, well, we only have the house, and then they realize the house is worth $250,000, and then they've qualified for formal administration because their parent hadn't planned or hadn't properly done the legal mechanisms ahead of time in order to prepare for their passing. So they have to go through a formal administration of probate because the house is worth $250,000.
So potentially almost everyone's going to go through probate.
And when I think that's why it's important that I always say non-probate assets is because it depends on the type of assets that you have. Typically, everyone's going to go through some form of probate, whether it's the no administration, summary administration, or formal administration. It depends on how lengthy or costly and that your type of administration is going to be.
So you don't just get a pass because you're some elite person.
Exactly. And usually the more money you have, the longer it is. So
right.
When you say elite, it's typically more costly and more lengthy for the people that have substantial assets than it is for people that have little to none.
So let's talk about why probate is a bad thing. So first of, it's in a courtroom.
Well, I wouldn't necessarily say it's a bad thing. I would say that it can be costly, it can be lengthy, and those are things that you want to minimize. It is a difficult process. Like I mentioned at the beginning of the show, it's not something that people that are grieving the loss of a loved one want to deal with. So while it's it is a court process, it's not
but it does
the
take
typical
time.
kind of court processes that we think about, where you go to criminal trial or it is a process though, and that's why, like you said, it takes time.
So how much time are we looking at?
The average formal administration, which most of my clients that come in are concerned with formal administration because they do have assets that we're planning for, and we wanted to make sure that we've got a strategic plan in place for those assets. And typical formal administration in Florida can take anywhere from 6 to 11 months.
Wow.
And, there's a lot of factors that vary into that too.
And it's not like they can continue taking so if I'm a beneficiary of an estate, I can't just take my inheritance and wait 6 to 11 months. I got to wait for that to go
exactly.
past.
And the way the Florida statutes define it, the beneficiaries are the last ones to receive the money from the estate.
So attorneys get paid first?
Taxes, attorneys, funeral expenses, those are all paid ahead of time before the beneficiaries receive a single penny.
So back to protecting your legacy, making sure that you're leaving your financial house kept up and not in disarray is the last thing, again, is you want to have your family go through 6 to 11 months of financial turmoil on top of the emotional grief they have of losing you. So that's why we, have a process called a probate preparation consultation. It's a free 1-hour consultation with Scott and I, and you can call both of our offices to schedule it. It's basically a 1-hour meeting, and I'll tell you exactly what it looks like. You'd bring in, what legal documents you already do have, a list of assets, and we'll find out if they're probatable or not non-probatable. And so we go through that together, which is why we believe so much in total wealth management, so that nothing slips between the crack between your elder law attorney and your financial advisor, and make sure that you are prepared for probate. And hopefully you come in and you're good to go, and we just put a stamp of approval saying, hey, you're doing good, keep it up.
And, it's important. I know I've been talking a lot about formal administration, and, we keep talking about that's the lengthy and costly one. But, one of the common misconceptions is that, if I don't have enough to reach formal administration, then I don't have to worry about probate. And that's not true either, because a lot of people don't understand that, and that's why we have levels of administration in Florida, is that, if you have less than $75,000, but you have over $1,000, you're going to qualify for what's called summary administration. And that can still be costly,
right,
depending on what you have to get transferred, the time it takes for attorneys.
So to prepare for that, you can schedule that consultation by calling our office at 850-380-9558. That's 850-380-9558.
Or you can call my office at 850-403-0351. Again, that's 850-403-0351.
Or visit us on the web at swan-capital.com. That's sleepwellatnight-capital.com.
And you can go to my website as well, where you can request a free consultation on. There's an actual place on the website to request that consultation. It's PensacolaElderAttorney.com.
That's pretty easy.
Yeah, it's Pensacola, elder as in elder law, attorney.com.
Perfect. And so we talked about how long probate can take. Let's talk about how much it can cost, though, too.
Well, the reasonable fee, I know, obviously, being an estate planning attorney, doing estate administration, that the reasonable fee that has been set out by the Florida legislator for what attorneys can charge is if you have anywhere from zero to, or I think it's actually not zero, it's from 50 to 100,000, I can charge 3% of that. And so if you have a home that's worth, $90,000, I can charge $3,000 on,
wow, or
almost $3,000 on the administration of that property.
So if you have $1 million estate,
you're looking at potentially $30,000 in estate administration charges just for the attorney. And that doesn't matter if it's just one home that's worth $1 million or if you have 86 bank accounts worth, totaling $1 million. So it's important to understand that the preparation for a probate process and making sure that you minimize that through legal mechanisms and planning can really be beneficial, not only to your legacy, but to the process for your loved ones when they're going through it.
It's all about that old proverb about, how big prevention is. Prevention can save you a lot of money and heartache ahead of time. But, most people, unfortunately, don't plan their next evening dinner. But so, planning for probate is, again, it's not an if thing. It's a when thing and how prepared you are for it. And so we talked, if you're just tuning in, you're listening to What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we're talking about probate. And so if you have any questions about the probate process, remember this show is live, and you can give our show a call at 478-3116. That's 478-3116. And we'll peel back the curtain on your question to make sure that you have an answer to your question before you grab and jump out of the car. We already do have a question from Terry. Terry, welcome to What Your Money Would Say.
Can you hear us, Terry? It looks like we may not have Terry.
We might have lost Terry.
She'll
call
Terry,
back.
If you're going to give us a call back, we will be glad to take your question.
So let's talk about walking through the probate process. What does that process look like?
So basically, the process starts with the collection of documents. You have, obviously, if your mother or father passed away, you have the will. If they did have a will, you have the will. You have any document that.
So we need a death certificate, right?
You need a death certificate. You need the deed. Any
pertinent
documents that are going to be part of the probate estate.
And you make it pretty easy because you have a questionnaire that has a list of things to fill out and documents to collect.
Exactly. And so in the next step in the process is after the document collection, I've met with the clients and I've talked to them about what needs to happen and what type of administration that we're going to have to file for. Once we've talked about that, I do file for a specific type of administration.
So you got to choose
exactly
based on the asset level.
Exactly. I don't really get to choose. Unfortunately, the court tells me if you have this much, you do this one. But so once we've determined which one we have to file for, that's what I go through the process of filling out all the petitions, the things that I need to file with the court. Then we file those with the court, and once we do that, then we wait for the court to begin to administer the estate. I have to do orders. There's a whole process.
It's a whole long process. And I want to get something across. Can families do probate by themselves?
The personal representative is allowed to do it by themselves. Obviously, I have material.
I always heard that you're not supposed to represent yourself in court.
There is an old saying that anybody that represents himself in court has a fool for a client.
Right.
And
because it's a process that you went through many years of schooling to do. I mean, it's not a piece of cake.
Exactly. And so, and like I said, I do have obviously some kind of beneficial gain for me to say you should hire an attorney because this is what I do and this is how I make money. But the reason I tell you that is because it is a process. And if you don't know what you're doing, you're going to miss steps. You're going to maybe not file the correct documents. You're not going to have everything that you need, and it's just going to make the process more arduous and more difficult.
Yeah, and that can be avoided by hiring a professional, and first off, and more importantly, preparing. And so that's why we offer a free probate preparation consultation, which is an hour meeting with Scott and I to make sure that your financial and your estate plan documents are in a row, to make sure that you're prepared for it when this untimely event finally happens. And so you brought up a good point about a document called a will. I've always heard as long as I have a will, I'll bypass probate.
And that is one of the common misconceptions, that if a lot of my clients come in the door, well, I have a will, I don't need to worry about probate. And I have to be the bearer of bad news and say, well, the will is just merely a guideline for the probate court to distribute the assets.
So, and we usually joke, where there's a will, there's a bill.
Exactly. I mean, the will is just the guideline for probate. And so if you have a will, yes, it does facilitate the process, but there's still going to be that probate process, regardless of whether or not you have a will. Now, unfortunately, there are people that die in Florida every day without wills. And so, Florida has come up with, the Florida legislature, in their infinite wisdom, has come up with a one-size-fits-all will for everybody. It's called our intestacy statutes. And what that does is that, because not everybody has a will, not everybody goes through the process, and
not everyone does it right either.
Exactly. And so,
a bar napkin ain't going to work.
Well, in Florida, no, it won't work. There are specific requirements for the creation of a will in Florida, but that's...
And how many countless times have we had people write it on a piece of paper, not notarize it? It's not even a proper legal document.
Yeah, I have clients that come in my office and say, "Oh, I have a will," and I say, "Well, can I look at it?" And I look at it and say, "Well, you do have a piece of paper here, but it's not going to fly when you have to submit it to the court." And I have to be the bearer of bad news again. They've downloaded something offline, or one of these pre-prepared, because there are a lot of sites out there you can Google now, wills creations, but they don't necessarily have all the Florida requirements.
Well, I mean, the best analogy I can give to you, it's like one of those, when you go to Breast Awareness Day and they give you one of those nice T-shirts. They're a nice T-shirt, but it looks like a mast on a boat. I mean, it don't fit you. It makes you curves. It shows curves you don't want to show. I mean, it makes you look bad.
Yeah, and that's the point I was kind of trying to make was that this intestacy statute is a one size fits all will. And, I have clients that come in my office and say, well, I don't want to give anything to my son, or I don't want to give anything to my daughter. But if you die without a will, the way the intestacy statute is written is those are the people that are going to get it. So if you have specific things that you want to say, you want to give to charities, or you want to, give to your local firehouse, whatever your local church, whatever church you attend, you have to spell that out in your will, because the court is not going to distribute it to those people. They're going to distribute it per the intestacy statutes if you die without a will.
Right. And so if you're, again, just tuning in, you're listening to What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we're talking about life's ultimate fire drill, estate planning, preparing for probate. And so we've talked about the cost. I mean, it can cost nearly 3% of your estate. So if you have $500,000, that could be potentially $15,000 in probate costs.
And I'm sorry to interrupt you. That's just attorney's fees. That's not the court filings, the costs of.
So wait, there's more.
There's taxes, and that's why, really planning and minimizing the probate process is so beneficial.
So not only do you have costs, you also have the time period. It can take 6 months to 11 months, and that's if it's not contested and you don't have family dynamics. So there's a lot that goes into preparing for probate, and that's why we offer a free probate preparation consultation. And I'll give you our office phone number so you can call to schedule that consultation, which is a 1-hour sit down with Scott and I to look at, I'll look at the financial investments you have to make sure they're they're non-probatable. He'll make sure that your estate planning documents are in order. And you can call my office to schedule that at 850-380-9558. And that's 850-380-9558. And you'll leave a message. You can even call right now on the weekends.
You can also call my office at 850-403-0351. Again, that's 850-403-0351. And as Andrew said, you can call right now, leave a message, and we will get back to you as soon as the office is open.
And now, before we go into a commercial break, I do want to give you our phone number here at What Your Money Would Say. Remember, this is a live show, so if you have any questions about probate, estate planning, and you just have a burning question you want to get answered, give our office a call at 478-3116. That's 478-3116. 3116. Welcome back to What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
So today we're talking about the ultimate fire drill. You know, preparing for a fire, it means interrupting your life for, 30 minutes. But the key is you're making sure you're prepared for untimely events. And what's more untimely than your passing? And the last thing I know you want to do is leave your legacy in disarray. And so that's why we're talking about the probate process that can take 6 to 11 months when someone passes. It can mean 3% or more in legal fees. It's a very expensive and hard process to go through for the ultimate beneficiaries of your estate. That can all be avoided or minimized. So we've been talking about a will with Scott Malleck. And again, remember, this show is live, so if you have any questions, call our office after the show to schedule a consultation. But if you have any questions right now, you can call the studio at 478-3116. That's 478-3116. So, Scott, let's talk about, so if a will is not enough, and a will still make us go through probate and give the judge something to read, what are some other legal documents that can help minimize?
Well, there are other options. I mean, like I said, if you have certain amounts of assets, we start to think about other types of mechanisms that may be beneficial for protecting your assets, such as, revocable living trusts, marital trusts, AB trust. There's a whole bunch of different types.
It's like Baskin Robbins. There's like 31 flavors of trusts.
Yeah. And so, I mean, there's a lot of different trusts out there that accomplish a lot of different goals. So it's very important to understand that depending on what goal you're trying to accomplish, it needs to be a specific trust that you're trying to draft and create.
Right. And trusts are not for everyone. I mean, you can potentially minimize or avoid probate by just titling your assets correctly. Is that not right?
Yeah, and that's true entirely. If you get, you could take, for instance, your property, it's your home or something. If you own it as a married couple, to making sure that you title it as tenants by the entirety. What that means is that as soon as one spouse dies, it automatically, by operation of law, passes to the other spouse, and that's a non-probate asset. And then going further, we have in Florida what are called ladybird deeds, which are essentially our enhanced life estate.
And we want to talk about ladybird deeds because that's the thing that anyone that owns a home in Florida should know about.
Exactly.
But remember, this show is live on What Your Money Would Say, and you can call with your question, your burning question, at 478-3116. That's 478-3116. So, Scott, what is a trust?
So a trust is just another legal document that is basically, a good analogy is a bucket. Basically, it's designed and built to hold assets as, and we kind of mentioned this when we were talking with Frank about titling. So when you title assets in the name of a trust, it becomes the legal title holder of whatever asset you've titled in its name.
So you don't lose control of it if you have a revocable living trust, because that's a lot of people's fear too.
In Florida, the way the courts deal with revocable living trusts is they treat them as alter egos of the person that's created them. Because
I like that name, alter ego.
And the reason I say alter ego is because the way that it is, or the way that it's seen through the eyes of the court, is that it's just an extension of your own self. And because you have so much control over it, you have the ability to revoke, amend, change, alter.
But why would I even need one if I have a will? I mean, when does a will become effective and when does a trust become effective?
Well, that's a really important distinction is between a will and a trust. A will becomes effective as soon as you pass away. Yes, you've created the will, but it doesn't become operative until you've passed away because it doesn't dispose of your assets until you die.
And isn't it funny how all the people come out of the woodwork on a will because dead people can't speak. So when you pass away, a will does not become effective till you pass away. And then you have Uncle, Bob that he swears that you promised him the boat. And so that's why you have a lot of those issues.
Yeah, and a trust is more essentially a contract. And what I mean by that is as soon as it's signed, it becomes an operative document in terms of between the grantor and the trustee. And I'm going to start throwing all these legal terms around. There are three basic components to every trust. You have the grantor, the trustee, and the beneficiary. The grantor is the person that creates the trust. The trustee is the person that you've chosen that you trust. That's why we call them trustees, to manage and take care of the property that's inside the trust, and then the beneficiaries, which
everyone knows what that is.
Everybody knows what a beneficiary is because they want to be the beneficiary of some trust estate, because they receive the benefit of the trust. So whatever assets are in there, when the benefits are being doled out, they're the ones that receive the benefits. And so those are the three basic components of any trust. Now there are, as I mentioned before, we started talking about this before the break. There are a bunch of different types of trusts that accomplish a bunch of different types of goals.
And not one is better than the other. I have a lot of people say, you got to get a revocable trust, don't get an irrevocable. And then I have a lot of people say the irrevocable trust is the only way to go. And there's no such thing as a bad trust, or they would get rid of them. It's just what's bad or right for you. And that's why it takes dealing with, two competent professionals, one an elder law attorney and one a financial advisor that specializes in estate planning and legacy planning. And so if you're just tuning into What Your Money Would Say, you're listening to Andrew McNair
and Scott Malleck,
and we're talking about probate, the ultimate life fire drill, if you will. Preparing your estate and your legacy to make sure it's not in disarray when that untimely event called death happens. And so if you have any questions that you would love to ask right now, we do still have a little bit of time in today's show. You can call the station at 478-3116. That's 478-3116, and we'll be happy to answer your question live on the air. So we're talking about trust. So a lot of families may already own a trust, like a living trust. So I want to talk about some of the mistakes we see, and I'll start us off. The first one I see is families will go into maybe a seminar that an attorney put on, and that person said, you got to have a trust. So they got a trust. They may paid a lot of money for it, $3,000 to $5,000. It's on nice linen paper, leather bounder. They feel really good about what they paid good hard-earned money for. And then they bring it into my office, and then I look through their Schedule A, which is the inventory sheet of the trust, and then I look at the titling of their documents. And then I have to be the bearer of the bad news, which is really hard to do, is to tell a family, basically, you have a $3,000 to $5,000 paperweight on your hands. Basically, you have a nice trust, but it hasn't been funded properly. Sometimes families will put the wrong different kinds of assets into it. Sometimes their financial planner to even put the assets inside the trust. Sometimes I've asked families, is your IRA, how are you going to take care of that when you pass away? And they say, oh, it's already taken care of. My IRA is in my trust. And then, again, I have to tell them an IRA can't go inside of a trust. It stands for an individual retirement account. So you want to make sure the mistake number one to avoid if you already do have a trust or looking into a trust is that you do fund it properly.
And I can tell you, this really does happen. It's part of the reason that I went into this type of law, is because my parents went through this process. They were thinking about what their estate planning they needed to do, and they went and saw a competent attorney, and he created an estate plan for them, and it included a revocable living trust, and they were going through the whole process, and unfortunately they realized that there was nothing in their trust because, the attorney created the trust for him, but he wasn't a financial expert. He didn't know or didn't tell them what they needed to put inside or how to even put their assets inside the trust. And
that's why we believe in total wealth management. Total wealth management is the concept. Scott and my office are all in the same office. We are separate entities, but what we do is we work together on every client to make sure that there's no legal cracks that are in someone's financial plan, and he makes sure that there's no financial cracks in their legal plan. And we push that together so nothing is misplaced, nothing is forgotten about, and they all are very synergistically working together for your behalf. And so if you're just tuning in, you're tuning into What Your Money Would Say, and I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we're talking about probate. And so if you want to schedule your probate preparation consultation, which is a 1-hour meeting with Scott and I, to look at your legal documents as well as your financial tools and investments and vehicles to see if they're probatable or non-probatable. And, I encourage you to schedule that meeting even on this weekend, and you can call our office. My office is 380-9558. That's 380-9558. Or visit us on the web at SWAN, which stands for Sleep Well at Night, -capital, CAPITAL. Or
you can give my office a call at 850-403-0351. Again, that's 850-403-0351. Or you can request a consultation on my website at PensacolaElderAttorney.com. Again, that's PensacolaElderAttorney.com.
And we'll be right back talking about all the other mistakes we see in living trusts, as well as some probate tips. We'll see you soon. We're back here on What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And so remember, this show is live. So if you have a question, either legal or financial, please give us a call at 478-3116. That's 478-3116. All right, so we've been talking about the ultimate life fire drill, probate. So probate is a lengthy process if you go through formal administration. So if you have over $75,000 of probatable assets, you could be at risk of going through 6 to 11 months of probate, also paying up to 3% or more in legal fees to facilitate this process. And this can be avoided with proper planning or minimized.
And it's really important. I mean, when I hear Andrew say probatable assets, we've had callers ask us about titling. It's really important to understand what probate assets are and why titling is so important, because you can have, like a life insurance policy that has beneficiaries is not a probatable asset because it has direct beneficiaries. But if you don't properly title things like checking accounts or your home or things like that, then those are all going to be included as probatable assets. And so you can really rise to that level of formal administration really quickly, especially with the values of homes nowadays.
Absolutely, if you're not careful. And so we left before commercial break talking about the mistakes about trusts, because just because you have a will doesn't mean you won't still get a bill. And that's the joke around the office, because a will just gives the judge and the probate court something to read and go by, but it does not necessarily avoid or minimize probate. So we talked about trusts, and trusts are not right for everybody, but they can be a great tool. But even if you have one, and maybe you're listening right now and you do have a living trust, there are some mistakes like funding it properly. The other one is what Scott's going to talk about.
And this is the biggest pet peeve of mine, is when people come in with their legal documents. It's not exclusive to trusts alone. It can be powers of attorneys, wills, trusts, anything of those documents is naming successors. And what I mean by successors is putting someone in place in case, say, your trustee or your power of attorney is unable to fulfill that role. Do we have somebody that can step up and immediately take their place in fulfilling that role? Because I don't know how many countless times I've had clients come in and say, well, I have this power of attorney or this trust. And then I look at it and I said, so what happens if you get, God forbid, you get diagnosed with dementia, or, you go to this point where you're mentally incapable of fulfilling this role? Who's going to step into that role?
There's no backup plan.
And there's no backup plan.
Or they do have a contingent and it's their wife or spouse. And I'm like, what happens if you get in an accident together? Because y'all do spend some time together, right?
Exactly. And, it's such an easy fix. And that's why, for me, it's my biggest pet peeve, is because I hate when, attorney, some people go and they pay good money. I mean, I
$3,000 to $5,000 sometimes.
And so I, as an attorney, expect, there's a lot. All of the people that I work with are professional and qualified, but they're, we're human. We make mistakes, and there's simple things that can be fixed. And having a successor is such a simple fix that it's so important to have, because it's a backup plan. And I have a saying, I hope for the best, but I plan for the worst.
Absolutely.
As an attorney, I think that's our requirement. Is I have to think about all the bad things that could happen. And
you brought a good point. As it never hurts, because we all are human. We can make mistakes. It's nice to have a few extra eyes on your legal documents and your financial investments. That's why we always say, it's impossible to get a second opinion from the person that gave you your first. So if you already have your legal documents, what you believe in a row, which, our last client on, I think it was Friday, thought their legal documents were in order, but they were missing a notarization stamp that could be key to implementing that document. And it can be avoided and overlooked if you don't have someone take a second look at it. And that's why we offer a probate preparation consultation, which is a 1-hour consultation with Scott and I. So you get 2-for-1 deal, I guess. And you get to meet with us, and we'll look at your financial investments to make sure that they're probatable or need to be shifted so they are non-probatable. And then he'll look over your legal documents to make sure that everything's in good order. And if it is, hallelujah, we'll give you a stamp saying, hey, you're good, and you have nothing to worry about. And you can call our office at 380-9558. That's 380-9558. And please call on the weekends, and we'll call you on Monday. I won't, but someone in my office will, to schedule that probate preparation consultation.
You can call my office as well. That's 850-403-0351. Again, that's 850-403-0351. And, I wanted to also talk about some of the other mistakes that I see is, we all have people in our family that are good with money, that are not good with money.
You're saying that we don't all have perfect families?
I know I have a perfect family. But.
Well, I don't. So, family dynamics is what we call it in our office. We got white sheep and black sheep.
And so it's really important to think about when you're drafting these documents, protecting the beneficiaries themselves. Because if you give, somebody that in your family member, it's unfortunate. Life happens. Things in life are not always perfect. I have clients that come in, they have family members that are gambling addicts, alcohol addicted, drug addicted. I mean, it's reality. It's life. It's something I have to deal with, but it's something that you need to prepare for. So, if you have somebody that's going to be a potential beneficiary of your estate that's got a gambling addiction, do you want them to inherit $200,000 all at once?
Right.
No, you want to protect them from themselves. So there are certain provisions, that we can talk about, that we can put into place to make sure that money will be better suited to take care of them for a much longer point of time than if they received it all at once and then they went over to Wind Creek.
Because the last thing you want to do is your legacy that you plan to make a positive impact on a family member, make a negative one because you gave them too much too fast. And I'll talk about the white sheep in the family. If your trust, your legal documents don't account for the white sheep in your family, the children or family member that actually is doing really well, maybe we have a client whose child is a Fortune 500 CEO. So if he gets his parents' inheritance immediately, he could have double taxation and a second estate tax. So that's why we work with that family to make sure we avoid those things. So those are two large mistakes: not having successors or contingents on your legal documents, and then the next one is not accounting for the black and white sheep of your family.
And really quick, the last thing that I want to talk about with legal documents is that it's not a one-time thing. It's a continuing.
Great point.
It's not an autopilot thing. And, I have people that come into my office that made wills 30 years ago, and I said, well, has anything changed? And usually in 30 years,
their children are not minor children.
Things have changed, and so family dynamics are constantly shifting. People want to be they want to disinherit, re-inherit, and so you need your legal documents to reflect your wishes as they are today.
They're like living, breathing documents. And so, we recommend every 3 to 5 years minimally you come in to check your legal documents if nothing's changed. But if things have changed, it's time to knock off the dust off those documents and come on in.
Exactly, because it's so important to have them as up to date as possible so that if something does happen, they do reflect your true wishes.
So if you're just tuning in to What Your Money Would Say, I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we're peeling back the curtain on probate. And what is probate? We talked about how it's a 6 to 11 month potential process. It can cost up to 3% or more in legal fees to go through. And just because you have a will, it doesn't bypass probate. And so we talked about trust and how trust can be a good tool to help you minimize probate, but it's not right for everyone. But I do want to talk about one last mistake that I see trusts. And they assume that no one's ever going to get sick. They assume that no one's ever going to get old. And so I want to talk to you about a benefit called Veteran Aid and Attendance. So if you're a veteran out there, even if you're not, you probably know one. And so this is going to be a very important part of our show that you remember. There's benefits that pay up to $25,000 a year tax-free. That's right, $25,000 a year tax-free to help pay for assisted living, skilled nursing, and home health care expenses for wartime veterans and their spouses. And we help about 300 families apply at our nonprofit, the Veteran Benefit Project, apply for these benefits. And so the last thing you want to do is have your trust not account for that. Right now, long-term care insurance, the average cost is long-term care expenses are $3,400 a month here in Pensacola, Florida. You may not need long-term care and assisted living or at home for the next 10, 20, 30 years. But this is something you got to remember. If it's $3,400 today, and in just 10 years, again, you might need it in 20 or 30, but just 10 years, it's going to be $5,297. So if you're not accounting for it, I encourage you not to go the ostrich route of putting your head in the sand. There are ways to make you eligible for these benefits that the VA has and hopes that you take advantage of. And
you mean it's rising faster than cost of living adjustments for Social Security?
Oh, gosh, way faster. Social Security, as you know, is 1.5 or 1.7 for the last 2 or 3 years. So it's obviously not even keeping even close.
What was the percentage that assisted living rose?
4.3%, wow. Which is crazy. So in 30 years, it could be even way higher than $5,297. So you got to plan for that and show your legal documents. So if you want to schedule that probate preparation consultation, I encourage you to call our office here at SWAN Capital, which stands for Sleep Well at Night Capital. And you can go to our website at swan-capital.com and call our office at 380-9558. That's 380-9558. And you can even call on the weekend to leave a voicemail, and we'll call you on Monday to schedule that free 1-hour consultation with Scott and I.
And if the same goes for my office, you can give my office a call at 850-403-0351. Again, that's 850-403-0351. Or if you want to go on my website and you happen to be more tech savvy, there is a way to, on the website, request a free consultation, and we will get back to you as soon as we're available on Monday, and we'll set up a consultation.
Now, there's a few other tips and pointers I want to leave with you about probate. Because we live in the beautiful inland coast of Pensacola, Florida, we're not that far from Lower Alabama either, so we're not far from L.A. And so because we live so close to Mississippi and Alabama, we have to talk about probate in multiple states because you may own property in Alabama and Florida. So Scott, tell us about that.
And the reality is that if a lot of my clients do, they have a home that they own in Gulf Shores and a home that they own in Pensacola proper. And so, if you do have that possibility, property is governed by the place where it resides. So the laws that are going to govern the Gulf Shore property are different.
It's not a federal probate court.
Exactly. The laws that govern the Gulf Shores property are different than the laws that are going to govern the Florida property. So it's important to understand that because we are so close, that there is a potentiality.
You don't want to go through double probate.
Exactly.
So again, you can call our office for that probate preparation consultation at 380-9558. That's 380-9558. See you next time on What Your Money Would Say.